I'm Mark Pollard. I'm a criminal defense attorney licensed to practice law in the state of New York. How to get a criminal case dismissed. Over the course of my career, I've used a number of different methods and techniques in getting cases dismissed for clients. I'd like to take a few moments to let you know about some of the things that I have done in the past. These are some things you might have heard of before. For example, there is the Alibi Defense. What that means is if you are accused of committing a crime at a particular date and time, if you have proof, be it witnesses or videos, that's always best, that you were in another state at the exact date and time, therefore you could not have committed this crime that the police are charging you with, then that is a great way to get the case dismissed. Another way to get a case dismissed is through the grand jury process. Everyone in the state of New York has a right, well, sometimes there's something called preliminary hearings, but you have a right to testify in a grand jury or a preliminary hearing and explain to the grand jury what your defense is, that this is a mistake, I didn't commit this crime. If the grand jury by majority believes you, then you can get the grand jury to dismiss the charges against you. Another technique that I've used is situations where it is, for example, a case of check fraud. And I would have the person take a handwriting analysis. And the handwriting analysis expert would prove that, no, the person that wrote these checks and deposited into my client's account was someone that stole his identity. You can look at the handwriting analysis. The DA can confirm that it's not my client's handwriting. Therefore, you should dismiss the case. Another way I've done it is I have experienced polygraph experts. Those are lie detector experts that will give my clients a polygraph. And if they pass the polygraph, I will take it to the DA's office and say, listen, you're making a big mistake. This polygraph expert known around the world that you know too, Mr. DA, has said that my client is speaking truthfully and there's no deceit in the polygraph test. That's another way that I've gotten cases dismissed. Of course, you always have the opportunity for your lawyer to argue speedy trial. By law, depends on what the charges are, there are different speedy trial limits, meaning if the DA is not ready for trial within 90 days, in some situations 6 months, then the lawyer can say, Judge, I've been ready for trial, all of these dates, the DA is not ready, the case should be dismissed pursuant to speedy trial. In New York, it's called CPL, Criminal Procedure Law 3030. The last way to get a criminal case dismissed is by going to trial. An experienced criminal lawyer will know how to defend you at trial. Remember this, the DA has the burden of proof in a criminal case. What does that mean? That means that the DA has to prove beyond a reasonable doubt that you committed the crime's charge. If a DA does not prove this, then the jury will find you not guilty, and then the judge will dismiss all of the charges against you. I'm attorney Mark Pollard. Thank you for listening. And remember that justice is when everyone has the same opportunity to life, liberty, and the pursuit of happiness. Thank you.